three points are covered: prohibitory, affirmative, 189, and resignation. Now, the fourth point is this prospective and retrospective of the EC. They're all important queries which fell from my lord. My lord, the Chief Justice asked this question more than once. Just forget everything else. I'll take one point here is enough. Whatever else your lordship holds, on the bare text, textually and facially, symbol order number 15, has to be prospective. Forget all the, we'll come to the interpretation. Just read the text facially. That's at para 15A of my note.
Yes.
Without anything more. We'll come to the consequences. As drafted facially, without any interpretation, it has to be only prospective. Kindly read. Power of the Commission in relation to splinter groups. Now, I've underlined some words. I've taken the liberty of underlining some words. When the Commission is satisfied on information on its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the Commission may, after taking into account all the available facts and circumstances, and hearing such reps of the sections or groups and other persons who desire to be heard, decide that one such rival section or group or none of such rival groups shall be binding. This cannot but be futuro. Number two, look at the consequences of holding otherwise. There will be very, very strange consequences. Two things, fellows. If your lordship were to hold the 19th July, that's the date, order of the EC.
17th February 20.
Sorry, 17th February 23. I'm sorry, 17th February. Petition is filed on 19th July. 17th February is the order. Now, the order to be retroactive, question number one, retroactive from when? There are three possibility retrospectivities. Look at the consequence. Whether the lordship doesn't hold it to be without the consequence. Three. One is, it is retroactive from the date the Shiv Sena was recognized as a 29A political party. That was in 1990 or 92. I'm giving you three alternatives. I'm not... because today I am the Election Commission, I hold that this is the Shiv Sena. If it is retroactive, logically it should go to the date when 29A. But let's leave that. Second, it goes back to 21st June when this action started. And third, it goes to 19 July when the petition was filed. There are only three possibilities, Malas. In all of these, the consequences would be that, Malas, actually everything, I would be guilty, but I am actually, I mean people who have remained with Mr. Thackeray. I'm just using a phrase because there's no other phrase available. And people who have left. Now, the people who have followed the 10th schedule and remained with Mr. Thackeray would be actually liable for disqualification if your lordship relates back that. So your lordship would be giving a premium to those who follow the 10th schedule, and the people who have not followed the 10th schedule will protect their disqualification also and disqualify me also. Whereas your lordships will not avoid the inevitable consequence by, of course, your lordship's words can always, that's the logical consequence of retroactivity. They would make an arc of immunity for their own disqualification and actually be liable because the party from 19th July, any whip, any order, everything, I have violated because I'm not the party from 19th July. And therefore, I'm liable to something. Or from actually, logically speaking, from the origin. Therefore, this... And it would have the strange effect of an election of Mr. Uddhav Thackeray in 2018. January. Would also go without there being a fresh election unseating him. Everything will go, Malas. No adjudication. By the mere act of recognition relating back either to 1990s or to 19th of July or to 23, 21st of June, there would be chaos. The consequences, are... And apart from the fact that this is clearly textually not intended by the symbols order. The fourth and the last, under this head, I'm not on the next one, under this head, it would also destroy, not collateral damage, major direct damage. It would destroy the relating back which is held by a lordship of Rajendra Rana. Now note this, note this. Not a single judgment even of any high court, leave aside Supreme Court, says that the election commission will relate back. A constitution bench has held the field for very long saying a disqualification 10th schedule order relates back. If your lordship were today to do this, your lordship would be giving primacy to an order under a symbols order, with any judicial precedent not saying so, versus a constitutional provision already held by a constitutional bench to relate back. And your lordships cannot reconcile a relation back of disqualification with a relation back of the EC. It can't be reconciled. Today, Malaz, suppose tomorrow the speaker disqualifies Mr. ABC. It is common ground by Rajendra Rana and many other cases. It relates back to Malaz, June 22. But there cannot be disqualification because by then your lordship also would be applying a EC order retroactively. Therefore, Malaz, your lordship already has jurisprudence and a precedent.
Prospective according to you.
All right. Then, Malaz, the fifth aspect is this political party and legislative party. Now, Malaz, F is a very important part. Actually, it goes to the root. This is the political party versus legislative party debate, but from an angle different than Mr. Sibal's. Kindly, Malaz, read this from a different perspective.
F, right?
Yes, F. Starting para 35, page 12. Malaz, members of a legislature party do not have any right to act contrary to the directions of their political party. This is the heart of the political party, legislative party debate, with which Mr. Call also started today at 2 o'clock. As per 194(1), the freedom of speech is subject to the provisions. I pointed it out already. Under 170(1), the assembly of a state consists of members. The members are elected by direct election from territorial constituencies, and the nature of the election process is such that an elected member set up by a political party has no independent identity in the house except as a member of the political party. Well, actually, in practice, how we sit, where we sit, which rooms we are given is all based on the collectivity of a party. Not an individual. Suppose a member is a leader of a party, he is very, very senior, but that party has only 3 seats. And another party with yesterday's first time member, but the party is a large number. Seats are allocated, rows are allocated, rooms are allocated only on the basis of party. That's the way it has to be. Now, prior to introduction, this is very, very important. Just kindly see this. This evolution has been forgotten in this argument of political party and legislative party. Prior to the 10 children, prior to 85, the constitution did not mention political party anywhere. Although in parliamentary democracy, the heart, as your lordship has in the English books, is political party. Westminster model is political party. Even though political parties were always recognized to be an essential component of the Westminster form of parliamentary government, political party as a term was defined for the purpose of election law in para 2H of the symbols order. Thereafter, through amendments, the ROPA, the Representation of People's Act, was put political party. They are the 2 statutory levels. It came in for the first time with the 10th schedule, which is a constitutional recognition of political parties. And today, a lordship is being asked to negate that recognition. Next para. On the other hand, the concept of a legislature party has no legal or statutory basis. A legislature party, by its very nature, is not a permanent association of persons. Its life is coterminous with the term of the House. The very coming into existence of a legislature party is dependent on a contingency, the success of more than one candidate belonging to a political party. The 10th schedule defines a legislature party in terms of a political party. That is conclusive, I say. According to me, I may be wrong. It's conclusive. Legislature party is defined in terms of the political party. I've quoted the definition. And your lordship is concerned with a whip. Whip is peculiarly a political party activity. I'm 41. The purpose of defining the group of members of the House belonging to one political party as a legislature party can be gathered from the number of times when legislature party is used. First, in 2.1, it says a member of a house belonging to any political party. What does it mean? Do you have an existence or identity other than the political party? After constitutional amendment and definition? Then, there is no mention of legislature party in para 2. In para 2, political party is mentioned. Thus, while referring to individual members, the 10th schedule refers to them as political party to which they belong and not relation to legislative party. The only place in the 10th schedule where the term legislature party is used was either para 3, now gone, or para 4. In para 3, the term legislature party was used when the fraction of 1/3 goes below. In para 4 too, it is for merger. Doesn't arise in this case. Doesn't arise in this case. Thus, wherever the 10th schedule provides protection to a group of legislators when acting as a group, it uses the term legislature party. Otherwise, it is described with reference to political party. Now, what is the consequence? This is a little important. The constitutional sequitur of this discussion is that a majority faction legislative party has no constitutional identity except for the purpose of setting up a defense under 4. This is important. Today, there is no status identity of a legislature party except for the defense of merger. That's all. And admittedly, that's not your case. Therefore, the group of legislators belonging to a political party can have no right of dissent or conscience. This dissent argument. Dissent has to be within the parameters of what 10th schedule allows you. Dissent cannot say that's too broad a basis for your lordships to act or give any judgment on ones. Dissent. I just say I'm dissenting and I leave the 10th schedule. Well, this dissent point which your lordship put to me just now also, let me end on that. Just see Justice Venkat in Kyoto. That para has been read one sentence, but read the whole of it. This is directly the point raised in Kyoto. Your lordship should not be referring to Nawab Revil, or should be reconsidering Kyoto also on this basis. Now, kindly see. This is a very important para. Para 49 at PDF page 109. 109. Very telling para. Directly the same sentiment. How do you harmonize the two, and you cannot allow one to be reduced to vanishing point? Kindly see this. Indeed, in a sense, an anti-defection law is a statutory variant of its moral principle and justification underlying the power of recall. What might justify a provision for recall would justify a provision for disqualification for defection. Now, kindly see the exact sentiment which my lords expressed to me. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful by the emotive political exaltations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. Can't be put better, Wallace. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation, it's grotesque in 92, I don't know how much more grotesque it is now today, especially with the 4-step procedure here, whose awkward erosion and grotesque manifestations have been the bane of the times, above certain theoretical assumptions. My learned friends have raised a theoretical argument, which in reality have fallen into a morass of personal and political degradation. We should, we think, defer to this legislative wisdom and perception. The choices in constitutional adjudications quite clearly indicate the need for such deference. Let the end be legitimate. Let it be within the scope of the Constitution, and by all means which are appropriate, which are adopted to that end. And here we have added, I have added 4 clear escape routes or mitigating circumstances. You don't follow them, but you follow this. This is extremely unfair. This is again like that technique of giving a notice to the speaker. It is trying to decimate the entire 10th schedule by saying dissent. Dissent has to be within the boundaries of that. But I'm extremely grateful and
thank you, Doctor.
Deeply obliged.
Thank you, Doctor.